Welcome back to Criminal Procedure, CRJU 201A. Today we're going to be discussing searches and seizures of property. Today's learning objectives are understanding search warrants, knowing the knock and announce requirement, knowing warrantless searches, understanding searches incident to an arrest, understanding the contemporaneous requirement, knowing searches incident to an arrest in automobiles, knowing misdemeanors and searches incident to arrest, understanding pretextual arrests, understanding consent searches, understanding third-party consent, understanding probable cause searches of automobiles, knowing other warrantless searches, and understanding inventory searches. The Fourth Amendment protects individuals from unreasonable searches and seizures and sets strict requirements for the issuance of warrants, which must be supported by probable cause, sworn under oath, and clearly specify the place to be searched and the items or people to be seized. Historically, the Supreme Court has expressed a clear preference for searches conducted under a warrant, reasoning that a neutral magistrate or judge is better suited to determine probable cause than a police officer actively involved in law enforcement. A detached judicial officer provides an independent check, while an officer in the field may face competing pressures in investigating the crime. Despite this preference, the court has recognized several exceptions allowing law enforcement to conduct searches without a warrant when circumstances require immediate action. These include searches incident to an arrest, searches of vehicles or recent vehicle occupants, consent searches, probable cause searches of vehicles or containers, and inventory searches. Warrantless searches exist to enable the police to respond quickly to potential threats or criminal activity, but they still must be balanced against the privacy rights protected by the Fourth Amendment. In considering these rules, the court continuously weighs the government's interest in investigating and preventing crime against the individual's right to privacy. While the warrant process offers a safeguard by requiring judicial oversight of probable cause, insisting on a warrant for every search could endanger officers, slow investigations, and obstruct crime prevention. As we proceed, the focus will first be on search warrants. Then we will explore the various types of warrantless searches and the legal justifications for them. Typically, in the study of law, you're always going to learn the rule first and then the plethora of exceptions to the rule. Courts evaluate the validity of a search warrant. Several foundational requirements must be satisfied. First, a warrant must be issued by a neutral and detached judicial official, typically a magistrate or judge, who is capable of making an independent determination of probable cause. The Fourth Amendment does not permit warrants to be issued by law enforcement officers or prosecutors who are actively involved in the investigation, because the purpose of the warrant process is to interpose a neutral decision maker between the police and the citizen. Second, every warrant must be supported by a sworn affidavit. The affidavit is the document that sets forth the facts and circumstances relied upon by law enforcement, and it is the vehicle through which probable cause is established. In some instances, if an affidavit is supported by the statements of a confidential informant or other witness, law enforcement can present the confidential informant or witness to the magistrate or judicial official potentially signing the warrant to allow them to bolster the credibility of their statements and the facts known to them in support of probable cause. Probable cause requires more than a hunch, but less than proof beyond a reasonable doubt. It exists when the facts would lead a reasonable person to believe that evidence of a crime will be found in the place to be searched. Probable cause may also support anticipatory warrants, which are warrants issued based on the expectation that evidence not currently present will arrive at a specified location before the warrant is executed. The Supreme Court approved this practice in United States v. Grubbs, recognizing that probable cause can be conditioned on the occurrence of a triggering event, such as the delivery of contraband. In the case of United States v. Grubbs, that contraband was child pornography that had been mail ordered. The scope of what may be searched or seized pursuant to a warrant is further defined by Federal Rule of Criminal Procedure 41, subsection C. Under that rule, warrants may authorize the seizure of evidence of a crime, contraband, or illegally possessed items, property used or intended to be used in the commission of a crime, or, in some cases, a person who is to be arrested or unlawfully restrained. A core constitutional requirement is the particularity of the place to be searched. The warrant must describe the location with sufficient detail to allow officers to find and identify the correct premises with reasonable effort, and to reduce the risk that another location will be mistakenly searched. Absolute precision is not required, but the description must eliminate genuine uncertainty. In most instances, officers are required to use the address, and if known, the apartment number of the location to be searched. Similarly, the warrant must satisfy the particularity requirement for the things to be seized. This requirement is designed to prevent general or exploratory searches by limiting officers to specific items connected to the suspected offense. The more precisely the items are described, the more tightly the search is constrained. Timing also matters. Under the doctrine of staleness, a search warrant must be executed while there is still a fair probability that the evidence remains at the location described. This is especially important in cases involving items that move quickly, such as illegal drugs. Federal law generally requires that warrants be executed within 10 days to ensure that probable cause has not grown stale. With respect to the time of day, search warrants are ordinarily executed during daylight hours. Nighttime searches are considered more intrusive and typically require a showing of reasonable cause or exigent circumstances to justify execution after dark. The scope of the search is defined by the object sought. Officers may search any area or container where the listed items could reasonably be found, even if that requires opening drawers, closets, or containers, as long as the search remains tied to the purpose of the warrant and does not involve unnecessary damage. The example we always used when we were explaining this to civilians or officers when training them on these requirements is, if you're actively searching for a rhinoceros, it doesn't make sense for you to search a jewelry box. So those are the types of parameters for size and shape that you would be looking for. Finally, the presence of third parties during the execution of a search warrant is tightly restricted. Inviting members of the media or other non-essential individuals into a private residence violates the Fourth Amendment because it exceeds what is necessary to carry out the search and undermines the privacy interests the Fourth Amendment is meant to protect. Electronic surveillance is governed by a layered statutory framework, much of which is built around legislation with names long enough to justify the profession's reliance on acronyms. Because saying all of this out loud every single time would turn any investigation into an endurance test. At the foundation is Title III of the Omnibus Crime Control and Safe Streets Act of 1968, which establishes the requirements for obtaining warrants to intercept telephone calls and other oral communications. Title III sets a high bar for wiretapping and eavesdropping, reflecting the intrusiveness of intercepting private conversations. States may authorize similar surveillance through their own implementing statutes, although not every state has chosen to do so. As technology evolved, Congress expanded these protections through the Electronic Communications Privacy Act of 1986, or ECPA. One of many examples where the acronym is far easier to remember than the full title. The ECPA extended privacy protections to electronic communications such as cell phone calls, emails, and computer-to-computer transmissions. Within ECPA, the Stored Communications Act governs access to stored data like voicemail and information held by Internet service providers, while later legislation such as the Cloud Act addressed how law enforcement may obtain data stored outside the United States. Additionally, statutory protections apply to more limited forms of surveillance. The PIN register statute, for example, regulates devices that capture dialing and routing information rather than the content of communications. To obtain a PIN register order, law enforcement must show a judge that the information sought is relevant to an ongoing criminal investigation, a lower standard than probable cause, reflecting the narrower intrusion involved. Congress has also required private companies to assist in lawful surveillance. Under the Communications Assistance for Law Enforcement Act of 1994, or CALEA, telecommunications providers must design their systems so that authorized monitoring can occur when legally approved. Following the events of September 11th, Congress enacted the USA Patriot Act, which expanded investigative tools related to national security and terrorism. Much of the electronic surveillance conducted under this authority falls within the framework of the Foreign Intelligence Surveillance Act, or FISA, which operates under a separate statutory and judicial process that we will address in a later chapter. When a judge is asked to approve a wiretap or other form of electronic interception, the application must satisfy several strict requirements. The government must establish probable cause that a specific offense is being committed, has been committed, or is about to be committed, and that particular communications related to that offense will be obtained through the interception. The application must also demonstrate that traditional investigative methods have failed and are unlikely to succeed or would be too dangerous to pursue. Finally, there must be probable cause connecting the targeted facilities or locations to the suspected criminal activity or to the individual under investigation. If a warrant is issued, it must be detailed and precise. The order must identify the applicant and the law enforcement agency, describe the offense under investigation, specify the types of communications to be intercepted and the facilities involved, and identify the individual whose communications are targeted. The authorization must also be time limited. Interceptions are subject to a minimization requirement, meaning that officers must avoid capturing communications that are unrelated to the investigation, and surveillance generally may not exceed 30 days without judicial renewal. The order must further account for prior surveillance applications involving the same individuals or locations and must provide for the secure recording and storage of intercepted communications, typically under court supervision. Finally, federal law recognizes limited exceptions to the warrant requirement in this context. A court order is not required in genuine emergency situations or when one party to the communication consents to the interception. The knock-and-announce principle has deep roots in the common law. As early as 1603, English courts recognized that government officials executing warrants were generally required to announce their presence and purpose before entering a home. This rule reflected the long-standing idea that the home holds a special status and should not be forcibly entered without warning unless circumstances demand it. Even at common law, however, the rule was not absolute. Officers could forcibly enter when admission was refused. That tradition carried over into American constitutional law. In Wilson v. Arkansas, the Supreme Court held that knock and announce is part of the Fourth Amendment's reasonableness inquiry. The court emphasized that the rule reflects respect for the home as an individual's castle and protects both personal privacy and physical safety. The knock and announce requirement serves several purposes: reducing the risk of violent confrontations, allowing occupants a brief moment of privacy and dignity, and preventing unnecessary property damage. At the same time, the Supreme Court has made clear that knock and announce is not required in every case. The Fourth Amendment does not demand adherence to the rule when doing so would interfere with effective law enforcement. Officers may dispense with knock and announce when they reasonably believe that announcing their presence would be dangerous, futile, or likely to result in the destruction of evidence. The Supreme Court addressed the scope of these exceptions in Richards v. Wisconsin, holding that there is no blanket exception to the knock and announce requirement, based solely on the type of offense being investigated, including narcotics offenses. Instead, officers must justify a no-knock entry based on the specific facts and circumstances confronting them at the time of the entry. We will examine Richards in detail next, so for now it's enough to understand that the court rejected categorical rules and requiring a case-by-case analysis was their ultimate determination. The court has reaffirmed this flexible, fact-specific approach in later cases. In United States v. Ramirez, the court upheld a no-knock entry where officers had reasonable suspicion that announcing their presence would be dangerous. These cases reinforce that the constitutionality of a no-knock entry depends on the circumstances known to officers at the moment they enter. Another important issue is how long officers must wait after knocking and announcing before forcibly entering. In United States v. Banks, the Supreme Court explained that the reasonableness of the waiting period depends on the context, including the size of the dwelling and the nature of the evidence sought. Officers are not required to wait so long that suspects can destroy evidence, flee, or arm themselves. In Banks, a wait of 15 to 20 seconds was reasonable given the ease with which drugs could be disposed of. Finally, the court has clarified that officers are not constitutionally required to knock only at a home's front door. In Carroll v. Carmen, the Supreme Court held that police may approach any entrance reasonably accessible to the public and reasonably believed to be used as an entryway. The Fourth Amendment does not impose a rigid front door requirement. Taken together, the knock and announce rule is best understood as part of the Fourth Amendment's broader reasonableness framework, one that balances the sanctity of the home against legitimate law enforcement needs, evaluated in light of the facts known to officers at the time of entry. In Richards v. Wisconsin, the Supreme Court considered whether police may categorically dispense with the knock and announce requirement when executing search warrants in felony drug cases. Building on Wilson v. Arkansas, the court reaffirmed that knock and announce is a component of Fourth Amendment reasonableness, but emphasized that it is not an inflexible rule and may yield when legitimate law enforcement interests are at stake. Police obtained a warrant to search Steiny Richards' motel room for drugs, but the magistrate expressly removed language authorizing a no-knock entry. When officers arrived in the early morning hours, one officer posed as a maintenance worker. Richards cracked open the door, saw a uniformed officer behind the ruse, and immediately slammed the door shut. After waiting only a few seconds, officers forcibly entered, announced themselves while doing so, and recovered cocaine and cash. Richards moved to suppress the evidence, arguing that the officers violated the knock and announce requirement. The Wisconsin Supreme Court upheld the search, reasoning that felony drug investigations always involve heightened risks of violence and evidence destruction, and therefore justify a blanket exception to knock and announce. The U.S. Supreme Court rejected that approach. Although the court acknowledged that drug investigations often involve dangerous circumstances and easily disposable evidence, it concluded that these general concerns do not justify eliminating case-specific judicial review. Justice Stevens explained that categorical exceptions rest on overbroad assumptions. Not every drug search presents the same risks, and some situations may not warrant an unannounced entry at all. The court also warned that permitting crime-based exceptions would rapidly erode the knock and announce principle, as similar arguments could be extended to many serious offenses. Instead, the constitutionality of a no-knock entry must be assessed based on the particular facts confronting officers at the time of entry. The court held that police may dispense with knock and announce when they have reasonable suspicion, not probable cause, that announcing their presence would be dangerous, futile, or likely to result in the destruction of evidence. This is a relatively modest standard, but officers must be able to articulate why the circumstances justified immediate entry. Richards argued that the officer's conduct was unreasonable because the magistrate had expressly declined to authorize a no-knock warrant. The court rejected this argument, emphasizing that the reasonableness of police conduct is evaluated at the moment of entry, not solely based on what was known when the warrant was issued. While the officers lacked sufficient information to justify a no-knock warrant in advance, the magistrate could not foresee the precise circumstances officers would encounter at the scene. Richard's apparent recognition of the police, combined with the readily disposable nature of the drugs, provided a reasonable basis for the officers' decision to enter without first announcing their presence. Accordingly, although the Supreme Court rejected Wisconsin's blanket exception to the knock and announce requirement in felony drug cases, it affirmed the judgment in this case. The officers' no-knock entry was reasonable under the Fourth Amendment based on the specific facts confronting them at the time of entry. March 13, 2020, Louisville police officers executed a late-night search warrant at the apartment of Breonna Taylor, a 26-year-old medical technician. Officers used a battering ram to force entry into the residence, where Taylor lived with her boyfriend, Kenneth Walker. Awakened by loud banging, Walker, who was lawfully armed, believed intruders were breaking into the apartment and fired a single shot in self-defense, striking an officer. Police responded by firing 32 rounds, several of which struck and killed Taylor. In a 911 call immediately after the shooting, Walker reported that the door had been kicked in and his girlfriend had been shot. Although the warrant initially authorized a no-knock entry, it was later amended to require knock and announce. The warrant was tied to a narcotics investigation involving two men, including Taylor's former boyfriend, who police alleged had received packages at her address. No drugs or contraband were found in the apartment. A central dispute concerned whether officers properly announced their presence. Police claimed they knocked and identified themselves, while Walker maintained that he heard only forceful banging and never heard police identify themselves. After entry, officers returned fire in response to Walker's shot. The incident led to significant disciplinary and legal consequences. Officer Brett Hankison was terminated for firing blindly into the apartment, conduct found to show extreme indifference to human life, and he was later indicted on reckless endangerment charges. Officer Miles Cosgrove, who fired the fatal shot, was terminated, and Officer John Mattingly retired. A fourth officer was fired for falsely stating in the warrant affidavit that postal inspectors had confirmed suspicious package deliveries to Taylor's residence. The investigation revealed serious procedural failures, including inaccurate police reports, the absence of body camera footage, and misrepresentations in the warrant application. Louisville ultimately settled a wrongful death lawsuit brought by Taylor's family for $12 million and enacted significant reforms, including banning no-knock warrants, mandating body cameras during warrant executions, and creating civilian oversight and accountability mechanisms. When police execute a valid search warrant, they are not limited to searching property alone. They may also detain certain individuals connected to the premises. In Michigan v. Summers, the Supreme Court held that officers may detain occupants found at the scene of a search warrant even without individualized reasonable suspicion or probable cause. The court justified this authority by pointing to officer safety, the need to prevent interference with the search, and the interest in ensuring that individuals do not flee while evidence is being uncovered. The limited intrusion on liberty, the court reasoned, is outweighed by these law enforcement concerns. The scope of permissible detention was expanded in Mueller v. Mena, where the court upheld the handcuffing and prolonged detention of occupants during a search involving suspected firearms, gang activity, and immigration violations. The court emphasized that the use of restraints and the duration of detention may be reasonable when justified by safety concerns and the nature of the investigation, even when the detention lasts several hours. However, the court placed important limits on this authority in Bailey v. United States. In Bailey, officers detained two individuals after they had left the premises that were about to be searched and stopped them approximately a mile away. Although the suspects were later connected to the apartment through keys and evidence found during the search, the Supreme Court held that the detention was unconstitutional. The authority recognized in Summers, the court explained, applies only to individuals located in the immediate vicinity of the premises at the time the warrant is executed. The court rejected the government's argument that detentions far from the scene could be justified by general safety or flight concerns. Once an individual has left the area, they no longer pose a meaningful threat to officers conducting the search, nor can they realistically interfere with it. Expanding detention authority beyond the immediate vicinity would risk turning a limited seizure into the functional equivalent of an arrest, significantly increasing the intrusion on personal liberty without adequate justification. To determine whether someone is within the immediate vicinity, courts consider factors such as the boundaries of the premises, whether the person remains within sight of the location, how easily they could re-enter the area, and other contextual considerations. Together, these cases illustrate the court's effort to balance officer safety and effective search execution against the Fourth Amendment's protection against unreasonable seizures. For the remainder of the chapter, we will be discussing warrantless searches. These include searches incident to the arrest of a person, searches incident to the arrest of a person who's in a motor vehicle or who has just exited a motor vehicle, misdemeanors and searches incident to those arrests, pretextual arrests and searches incident to the same, consent searches, probable cause searches of automobiles, probable cause searches of containers within automobiles, inventories, and other warrantless searches. It's worth noting that inventories aren't technically considered searches in some circuits, but they fall within the same category and they receive mostly the same treatment, so they'll be discussed here. A search incident to arrest is a limited warrantless search conducted to protect the officer, prevent the arrestee from fleeing or resisting, and preserve evidence from destruction or concealment. The scope of this search is restricted to the arrestee and the area within the arrestee's immediate control, sometimes called the grab or lunging area, where the person could access a weapon or destroy evidence. Areas beyond the arrestee's immediate control generally require a warrant. The court emphasizes that these searches must be contemporaneous with the arrest, ensuring that the intrusion into private spaces is limited to what is necessary to achieve the purposes of officer safety and evidence preservation. In Riley v. California, 2014, the Supreme Court applied this principle to modern technology, holding that the police generally need a warrant to search a cell phone incident to an arrest because of the vast amount of personal information such devices contain. In fact, it's been really interesting to watch the law regarding cell phone access by officers develop. It appears that cell phones are starting to get this similar treatment to homes. It's something with so much personal information that you normally would have stored in your home that you carry around in your pocket. So courts are really restrictive on police access to cell phones, and Riley v. California really emphasized that point. On September 13, 1965, police officers arrived at Ted Chimmel's home with a warrant to arrest him for burglary. They knocked on the door, spoke briefly with Chimmel's wife, and were invited inside. When Chimmel returned home, they served the arrest warrant. Even though Chimmel objected, the officers began searching the house without a separate search warrant. During this search, officers went through the entire three-bedroom home, the attic, the garage, and a small workshop. In some rooms, the search was brief, but in others, like the bedrooms, they had Chimmel's wife open drawers and move items to uncover anything related to the burglary. In the end, they seized coins, medals, tokens, and other objects. The search lasted about 45 minutes to an hour, and these items were later used against Chimmel at trial. The Supreme Court held that while it is reasonable for officers to search the arrestee in the area within the arrestee's immediate control, there is no justification for searching other rooms, containers, or the entire house without a separate search warrant. This limitation ensures officer safety, preserves evidence, and respects Fourth Amendment protections. The court emphasized that the reasonableness of a search incident to arrest depends on the circumstances at the time of the arrest, not on what a magistrate might have imagined in advance. Even if officers have probable cause to search more broadly, extending the search without a warrant would effectively create a general warrant, which the Fourth Amendment prohibits. Arresting someone inside their home does not give the police carte blanche to search the entire residence. The authority to search is strictly limited to the arrestee and their immediate area of control. This principle has been adapted to modern contexts, such as in Riley v. California, which we will discuss next. David Riley was stopped by police for driving with expired registration tags. During the stop, officers discovered that his license was suspended and impounded his car. A search of the vehicle uncovered 2 loaded handguns, and Riley was arrested. Officers also seized a smartphone from Riley's pocket. After the arrest, detectives examined the phone at the station and discovered photos, videos, and messages linking Riley to gang activity and a prior shooting. Riley was subsequently charged with several violent crimes, including assault and attempted murder. He moved to suppress the evidence obtained from the phone, arguing that the warrantless search violated the Fourth Amendment. The Supreme Court considered whether the search incident to arrest doctrine, which allows officers to search an arrestee in their immediate possessions to protect officer safety and preserve evidence, extends to modern cell phones. The court emphasized that cell phones are fundamentally different from physical items like wallets or purses. Unlike those items, a phone can store vast quantities of highly personal data: messages, photos, browsing history, location data, financial records, and more. The court highlighted both quantitative and qualitative differences. The quantitative differences were that a single cell phone can hold millions of pages of text, thousands of photos, and hundreds of videos, far exceeding the scope of what a typical search of physical items would uncover. A qualitative analysis showed that the data can reveal intimate details of a person's life, including location history, social connections, political and religious beliefs, and private communications. Phones also access cloud data, which can be stored remotely and synced across devices. The court explained that unlike physical items, the data on a phone cannot be used as a weapon to harm officers or destroy evidence immediately at the scene. While police suggested concerns about remote wiping or encryption, these issues are manageable through precautions, like turning off the phone or using Faraday bags, or case specific exceptions like exigent circumstances. The court concluded that the privacy interests in cell phone data are so significant that they outweigh the traditional justifications for a warrantless search incident to arrest. The exception does not automatically apply to digital devices. Police must generally obtain a warrant before searching the contents of a cell phone seized during an arrest. Warrantless searches may still be justified under other exceptions, such as exigent circumstances, but the general rule is that digital data requires judicial authorization. Modern cell phones are treated as extensions of personal privacy, containing vast and sensitive information. The Fourth Amendment protects this data, and officers must obtain a warrant before accessing it, even incident to a lawful arrest. Police arrest someone for drunk driving. They may seek to measure blood alcohol concentration. In Birchfield v. North Dakota 2016, the Supreme Court held that breathalyzer tests can be administered without a warrant, but blood tests generally require one. The court explained that a breathalyzer is minimally intrusive, measures only alcohol in the breath, and does not reveal additional private information. Exhaling into the device is not embarrassing, and the air does not remain in police possession. In contrast, blood tests are more invasive, provide a physical sample that can be preserved, and may reveal sensitive information beyond alcohol content. Exigent circumstances, such as the natural metabolism of alcohol, can justify a warrantless blood test in certain cases. The key principle, though, is that privacy interests and the intrusiveness of the test determine whether a warrant is required. A search incident to an arrest must be contemporaneous with the arrest. That is, conducted immediately before, during, or shortly after the arrest, according to Rawlings v. Kentucky 448 U.S. 98. The purpose of this rule is practical. Delaying a search would give the suspect time to destroy evidence or grab a weapon, undermining officer safety and law enforcement objectives. Searches remote in time or place from the arrest are generally unreasonable under the Fourth Amendment. For example, in Preston v. United States, police arrested 3 men in a car and later searched the vehicle at the station. Because the search occurred after the suspects were secured and could no longer access weapons or evidence, the Supreme Court held it was not incident to the arrest. By contrast, if a search occurs immediately as the arrest is made or shortly thereafter, it is likely justified. There are exceptions. In United States v. Edwards, 1974, the court allowed the seizure of evidence from an arrestee's clothing 10 hours after the arrest at the jail. The court reasoned that effects in the arrestee's immediate possession, items immediately associated with the person, that is, can be searched later if necessary. Lower courts have applied this reasoning flexibly. In Curd v. City Court of Judsonia, 1998, a purse search 15 minutes after arrest at the station house was considered constitutionally acceptable. The key principle is that searches incident to an arrest must be closely linked in time and place to the arrest, though courts recognize some flexibility for items closely associated with the person. Police conduct a search incident to an arrest. The ability to search containers depends heavily on timing and control. In United States v. Chadwick, federal agents followed 2 suspects after a train arrival, observed them handling a locked footlocker, and developed probable cause that it contained drugs. After arresting the suspects and taking exclusive control of the footlocker, officers transported it to a federal building and opened it without a warrant more than an hour later. The Supreme Court held that this search was not a valid search incident to arrest. Although the container was seized at the time of the arrest, the critical point was that the suspects no longer had access to it. Once officers have exclusive control over a container, and there is no realistic danger that the arrestee could retrieve a weapon or destroy evidence, the justifications for a warrantless search disappear. The court emphasized that individuals maintain a strong expectation of privacy in personal luggage, particularly when it's locked. At that point, opening the container requires a search warrant, even though the arrest itself was lawful. The court noted that the outcome might have been different had the footlocker been opened at the scene of the arrest, while access concerns still existed. Chadwick thus draws a clear line. Seizing a container at the time of arrest does not automatically authorize a later warrantless search once police have secured it. Consider how this is different than what we just previously discussed, where a purse or personal effects that are taken into custody with the individual can be searched, incident to arrest, even if there's an extended period of time between them. Why do you think that is? When an arrest occurs in or around an automobile, the Supreme Court has had to determine how the area of immediate control concept applies in a vehicle setting. In New York v. Belton, the court adopted a clear administratable rule. When police make a lawful custodial arrest of an occupant of a vehicle, they may search the entire passenger compartment of that vehicle as a contemporaneous incident of the arrest. The court reasoned that items inside the passenger compartment are generally within the area an arrestee could reach for weapons or evidence. As a result, containers found inside the passenger compartment, such as jackets, bags, or other personal items, may also be searched without a warrant. The court later extended this rule in Thornton v. United States, holding that Belton applies not only when police first encounter a suspect inside a vehicle, but also when the suspect is a recent occupant who has just exited the car. Once officers have probable cause to arrest a recent occupant, they may search the passenger compartment to protect officer safety and preserve evidence. These decisions, however, generated concern that the rule permitted searches even when the justifications for a search incident to arrest were weak. As we will discuss in Arizona v. Gant, the Supreme Court significantly narrowed Belton's reach. The court held that police may search a vehicle incident to arrest only when one of two conditions is met. First, when the arrestee is unsecured and could realistically access the passenger compartment, or second, when it is reasonable to believe that the vehicle contains evidence related to the offense of arrest. Gant thus restores the connection between vehicle searches incident to arrest and the core Chimmel rationales of officer safety and evidence preservation, while rejecting automatic searches once an arrestee has been fully secured and poses no realistic access risk. In Arizona v. Gant, 556 U.S. 332, 2009, the Supreme Court clarified the limits of vehicle searches incident to arrest. The case arose after Rodney Gant was arrested for driving with a suspended license. Police officers first learned of Gant through an anonymous tip about drug activity at a nearby residence. When officers returned to the residence, they arrested other individuals for unrelated offenses. Gant arrived shortly thereafter, parked his car, and was arrested about 10 to 12 feet from his vehicle. He was handcuffed and secured in the back of a patrol car before officers searched his car and discovered a bag of cocaine in a jacket pocket on the back seat, as well as a gun. The key issue was whether the search incident to arrest exception justified a vehicle search when the arrestee was secured and could not access the vehicle. Gant argued that Belton did not permit the search because he was handcuffed and the offense, driving with a suspended license, was unrelated to the likelihood of finding evidence in the car. The Arizona Supreme Court agreed and held that the search was unreasonable under the Fourth Amendment. The Supreme Court's majority reiterated that searches incident to arrest are justified only by officer safety and evidence preservation. As established in Chimmel v. California, applying this principle, the court held that Belton's broad rule allowing searches of any vehicle occupied by a recent arrestee does not apply when the arrestee is secured and cannot reach the passenger compartment. The court also added that vehicle searches incident to arrest are permissible if it is reasonable to believe the car contains evidence of the offense of arrest. In Gant's case, neither justification existed. He was secured in a patrol car, and the offense of driving with a suspended license offered no basis to expect evidence in the vehicle. Therefore, the search violated the Fourth Amendment, and the Arizona Supreme Court's suppression ruling was affirmed. Justice Alito's dissent, joined by Chief Justice Roberts and Justices Kennedy and Breyer, criticized the majority for effectively overruling Belton and Thornton. Alito argued that Belton provided a clear, bright-line rule that had been taught to police officers for nearly 3 decades. Many officers relied in good faith on Belton to conduct vehicle searches, and limiting it to reaching distance or evidence-related searches would reintroduce the very case-by-case uncertainty that Belton was meant to eliminate. Alito also challenged the majority's reinterpretation of Chimmel, noting that Chimmel did not specify whether the area within the arrestee's reach should be measured at the moment of arrest or at the time of the search. In practice, most arrests involve securing the suspect before conducting a search. By requiring officers to reassess the arrestee's access or to guess whether the car contains evidence of the offense, the court created a rule that could undermine officer safety and complicate routine law enforcement procedures. Alito warned that this approach might incentivize officers to delay securing suspects in order to preserve the ability to conduct a search under the new rule. In summary, Gantt sharply limits the vehicle search incident to arrest exception. A search is only permissible if the arrestee is unsecured and within reaching distance of the passenger compartment, or if there is reason to believe the vehicle contains evidence of the offense of arrest. While the majority emphasized constitutional protections and privacy interests, the dissent highlighted the practical consequences for law enforcement and reliance on long-standing precedent. The Supreme Court has held that a search incident to an arrest is authorized regardless of the severity of the offense. In Atwater v. Lago Vista, police arrested Gail Atwater for failing to wear a seatbelt. Although Atwater posed no threat and there was no evidence to be destroyed, the court confirmed that any custodial arrest allows a search of the individual arrested, without requiring a belief that the suspect is armed or that evidence might be concealed. United States v. Robinson, 1973, illustrates this principle. Officer Richard Jenks stopped Willie Robinson for driving with a revoked license. After arresting him, Jenks searched Robinson and discovered heroin hidden in a cigarette package. Robinson argued the search was unlawful because the offense was minor and there was no indication that he was armed or that evidence of the offense could be destroyed. The Supreme Court rejected this argument. They held that it is the custodial arrest which gives rise to the authority to search. It is of no moment that Jenks did not indicate any subjective fear of Robinson, or that he did not himself suspect that Robinson was armed. In Gustafson v. Florida, 1973, the court upheld a full search of James Gustafson after arrest for driving without a license, despite no officer fear or expectation of finding evidence. These cases establish a bright-line rule. The fact of a custodial arrest alone authorizes a search incident to arrest regardless of the offense. Why a bright-line rule? The court typically doesn't choose to establish a bright-line rule. But this time, the court cited 4 justifications. Courts lack the resources to assess reasonableness in every single arrest search. Full searches protect officers beyond what a limited frisk could achieve. Searches may uncover evidence of other crimes, and the intrusion is minimal into one person's privacy once an individual is arrested. However, in Knowles v. Iowa, 1998, the court limited this authority in cases involving citations rather than custodial arrests. An officer stopped Patrick Knowles for speeding, issued a citation, and searched his vehicle, discovering marijuana in a pipe. The Supreme Court held that the historical rationales for searches incident to arrest, officer safety and evidence preservation that is, did not justify a search when only a citation was issued. The court reasoned that the officer's safety concern is far less during a citation than a custodial arrest. There is no risk of evidence destruction related to the traffic violation. Any incidental discovery of unrelated contraband is too remote to justify a search. The court emphasized that extending searches incident to minor traffic stops would create incentives for officers to arrest rather than cite for safety concerns, but the ruling preserves a clear distinction. Custodial arrests permit searches, citations do not. As previously noted in United States v. Robinson, Officer Richard Jenks stopped Willie Robinson for driving with a revoked license. During the stop, Jenks conducted a pat-down and discovered heroin. Robinson alleged that Jenks had used the traffic stop as a pretext to search for narcotics, relying on Robinson's prior drug arrests. A pretextual stop is a law enforcement practice where an officer stops an individual for a minor violation, such as a traffic infraction, while suspecting them of involvement in a more serious crime. The Supreme Court did not address whether the stop was a pretext, observing only that Robinson had been lawfully arrested. Justice Thurgood Marshall dissented, emphasizing that an arrest may not be used as a pretext for a search for evidence. Next, we will discuss Wren v. United States. When reviewing Wren, consider whether the stop was truly a pretext. Ask why the court held that an officer's subjective intentions should not affect the reasonableness of an arrest and search. Also, consider whether the reasonable officer test proposed by the defendants would be practical for policing and law enforcement. In Wren v. United States, the Supreme Court addressed whether a traffic stop conducted by police officers with probable cause for a civil traffic violation could be challenged under the Fourth Amendment if the officers were motivated by an ulterior investigative purpose. On June 10, 1993, plainclothes Vice Squad officers patrolling a high-drug area of Washington, D.C., observed a Pathfinder truck with temporary license plates stopped unusually long at a stop sign. When the truck abruptly turned without signaling and sped away, the officers pursued it. Officer Soto approached the driver's window, identified himself, and directed the driver, James Brown, to put the vehicle in park. At that moment, the officers immediately observed petitioner Michael Wren holding 2 large plastic bags of what appeared to be crack cocaine. The officers arrested both Wren and Brown and seized additional quantities of illegal drugs from the vehicle. The petitioners argued at a pretrial suppression hearing that the stop was pretextual in nature, asserting that Officer Soto's justifications that the traffic violations required enforcement was a ruse to investigate suspected narcotics activity. They also contended that as African Americans, they had been singled out and that the stop violated police regulations, limiting plainclothes officers in unmarked vehicles to stops only in situations that posed a threat to public safety. The Supreme Court held that probable cause to believe a traffic violation occurred renders a stop reasonable under the Fourth Amendment. Regardless of the officer's subjective motivations, the court emphasized that Fourth Amendment analysis is objective, and an officer's personal intentions or pretext for stopping a vehicle are irrelevant if probable cause exists. The court distinguished these concerns from racially selective enforcement, which would implicate the Equal Protection Clause rather than the Fourth Amendment. The court rejected the petitioner's proposal of a reasonable officer standard, which asked whether a typical officer in the same circumstances would have enforced the traffic law for the stated reason. The court explained that such an approach would be unworkable, as police practices and regulations vary across jurisdictions, and it would require speculative assessment of hypothetical officer motivations. Moreover, attempting to judge the significance of technical traffic violations or the enforceability of obscure regulations would create inconsistent Fourth Amendment protections. The court concluded that the stop of Wren and Brown was objectively reasonable because probable cause existed to believe they had committed traffic violations. The subsequent discovery of drugs during the search incident to arrest was therefore lawful. The convictions were affirmed. Search conducted with consent is considered a reasonable Fourth Amendment search. When an individual voluntarily consents to a search, they effectively waive their Fourth Amendment right to privacy, giving law enforcement legal authority to search a person, vehicle, container, or home, even in situations where no other legal justification exists. Consent searches are a standard investigative tool for police and often provide the only way to obtain evidence quickly and reliably. The key legal test for a consent search is voluntariness. Consent must not result from express or implied duress, coercion, or intimidation. Whether consent is voluntary is determined by examining the totality of the circumstances, with awareness of the right to refuse consent being just one factor among many. While informing individuals of the right to refuse may reduce police effectiveness, it also protects individuals' privacy and autonomy. The burden of proving voluntariness rests on the prosecution, which must show by a preponderance of the evidence that the consent was freely given. Courts weigh multiple factors in assessing voluntariness, including coercive police procedures. that is, whether the environment or behavior of officers could pressure someone into consenting, the number of requests for consent, with repeated requests undermining the finding of voluntariness, custody or restraint, where individuals who are under arrest or handcuffed are less likely to give truly voluntary consent, awareness of the right to refuse, which is the knowledge that the individual has the right to give consent or to refuse that consent, experience with the criminal justice system. Familiarity may reduce a susceptibility to coercion by the police. Consent forms. Signing a written consent form strengthens the evidence of voluntariness, though verbal consent alone may be sufficient. Miranda warnings. Being read Miranda rights can reinforce the voluntary nature of consent because at that point, the individual giving consent is aware of all of their legal protections from law enforcement at that time. Concealment of contraband. Hidden evidence may indicate consent was given without expectation that it would be found. A classic example involves a driver stopped at an immigration checkpoint who voluntarily allowed agents to search a truck trailer. Although the driver was not informed of the right to refuse consent, the search was held voluntary because the driver understood the request, cooperated without coercion, and may have assumed the hidden contraband would not be discovered. Courts have also identified circumstances where consent is not voluntary. Where there's a lack of consent, then of course it's not voluntary. Mental disability or diminished capacity is always a consideration, especially amongst vulnerable individuals who may not understand the request. Threats to obtain a warrant by officers who say, "You either let me search this or I'll get a warrant," may render any consent received thereafter involuntary. False claims of a warrant. So when officers falsely state that they have a warrant, even though they clearly don't, that means that any search thereafter is involuntary. Direct coercion. Threatening harm to compel consent invalidates the search. Deceptive trickery. Misrepresenting the purpose of the search also undermines voluntariness. Some state constitutions require police to inform individuals of the right to refuse consent for home searches, emphasizing a knowing and voluntary standard, particularly in knock and talk encounters. Courts generally allow consensual approaches to open entrances, but searches become unconstitutional if the police use weapons, threats, coercion, or enter areas with a reasonable expectation of privacy without a warrant. Consider whether the voluntariness test appropriately balances police investigatory needs with individual Fourth Amendment protections, or whether suspects should always be informed of their right to refuse consent before a search is conducted. In Schneckloth v. Bustamante, 412 U.S. 218, 1973, the Supreme Court was asked to decide whether valid consent requires that a person know they have the right to refuse, or whether consent can still be valid even if that knowledge is absent. Late at night, police stopped a car in California for traffic violations. 6 men were inside. The driver did not have a license, and the officer asked the group for identification. Only one passenger, Joe Alcala, could provide it. The police then asked Alcala for permission to search the car. Alcala responded, "Sure, go ahead," and even helped open the trunk and glove compartment. During the search, police found stolen checks hidden under the back seat, which led to criminal charges. At trial, the defendant argued that the search was unconstitutional because Alcala had not been informed that he could refuse consent. The question before the Supreme Court was whether or not police must prove that a person knew they could refuse before consent to a search can be considered voluntary. However, the court rejected a strict knowledge-based rule. Instead, it applied a totality of the circumstances test, asking whether consent was given freely and voluntarily, without coercion or pressure. The court explained that voluntariness depends on all surrounding circumstances, including the environment of the encounter, the conduct of the officers, the characteristics of the person giving consent. Knowledge of the right to refuse is one relevant factor, but it is not required. The court emphasized that requiring officers to warn individuals of their right to refuse would seriously interfere with routine police investigations and make consent searches impractical. Consent searches often occur quickly, informally, and in everyday settings like roadside stops or home encounters, not in custodial interrogation environments. The court also stressed that consent searches can benefit individuals by allowing police to quickly confirm innocence and avoid unnecessary arrest or more intrusive investigations. As long as consent is not the product of threats, force, deception, or intimidation, it may be constitutionally valid. Therefore, consent is valid if it is voluntary under the totality of the circumstances. Police are not required to prove that the individual knew of the right to refuse. However, Justice Douglas dissented. He argued that a simple verbal yes does not necessarily reflect free choice, since people often interpret police requests as commands backed by authority. Justice Marshall strongly disagreed with the majority and emphasized that true consent requires informed choice. He argued that a person cannot meaningfully waive a constitutional right without knowing that refusal is an option. In his view, the court's decision allows police to benefit from citizen ignorance and disproportionately harms less educated and vulnerable individuals. Marshall warned that the ruling effectively protects only the informed and sophisticated, leaving others exposed to subtle pressure and coercion. The Supreme Court has made clear that being under arrest does not automatically invalidate consent to search. Instead, the same voluntariness standard applies even when a person is in police custody. Like in United States v. Watson, which we discussed in Chapter 5, postal inspectors arrested Henry Watson in public for offenses involving stolen credit cards. A search incident to arrest did not uncover any contraband, so officers asked Watson for permission to search his car. Watson agreed, and stolen credit cards were discovered inside. Watson argued that his consent was coerced because he was under arrest and custody at the time. The Supreme Court rejected his argument, however, holding that custody alone does not make consent involuntary. The court focused on the overall circumstances of the encounter. Watson was arrested on a public street rather than inside a police station. There were no threats or promises, and no evidence of physical or psychological pressure. He was given Miranda warnings and was informed that anything found could be used against him. The court also noted that Watson had prior experience with law enforcement and was capable of making a voluntary decision. Although Watson was not told explicitly that he could refuse consent, the court emphasized that knowledge of the right to refuse is only one factor and is not determinative. Under the totality of the circumstances, Watson's consent was voluntary. This reasoning has since been extended by lower courts to approve consent searches even when suspects are held inside police stations, as long as the surrounding circumstances demonstrate voluntariness. In Ohio v. Robinette, the court later addressed a related issue, which involved a traffic stop rather than a formal arrest. Robinette was stopped for speeding and issued a verbal warning. After returning Robinette's driver's license, the officer immediately asked whether he was carrying drugs or weapons and requested consent to search the vehicle. Robinette agreed, and drugs were found. Robinette argued that his consent was invalid because the officer did not explicitly tell him he was free to leave before requesting consent. He claimed that the continued questioning amounted to an unlawful detention. The Supreme Court once again rejected this argument. It held that police officers are not required to inform individuals that they're free to go before requesting consent to search. Instead, the question is whether, under the totality of the circumstances, a reasonable person would have felt free to leave. Because Robinette's license had been returned and the traffic matter was complete, the court concluded that a reasonable person would have felt free to go, and therefore the continued encounter and consent to search were constitutionally valid. However, I want you to consider real-life scenarios. Would you have felt safe pulling away when an officer asked you an additional question after handing you your license? I know I certainly wouldn't have felt free to leave, and I'm a lawyer. I know when it ends. But that's the Supreme Court's ruling, and it still stands. When police conduct a consent search, the scope of that search is defined by what a reasonable person would understand the consent to include. In Florida v. Jimeno, the Supreme Court held that consent to search a vehicle for drugs reasonably includes permission to open containers inside the vehicle that could hold narcotics. Even if the suspect did not specifically intend to allow officers to open bags or containers, the standard is objective reasonableness, what an ordinary person would have understood from the exchange. However, officers may not exceed the specific purpose for which consent was given. In United States v. Di the defendant consented to a search of his home for narcotics, but federal agents went beyond that scope by examining and seizing personal financial records. The court held that this exceeded the scope of consent because searching private papers was not reasonably necessary to determine whether narcotics were present. The scope of consent becomes more complicated in body searches. In United States v. Rodney, the court held that consent to a body search for drugs reasonably includes limited contact with the crotch area, given that narcotics are frequently concealed there. However, the court emphasized that this consent does not extend to body cavity searches or highly intrusive contact, which require separate and explicit consent. Consent is not irrevocable, and individuals may withdraw or limit their consent at any time. The withdrawal, however, must be clear, unambiguous, and unequivocal. In United States v. Fuentes, the defendant initially consented to a search, but withdrew that consent by verbally objecting and physically resisting before the officer removed the drugs from his pocket. The court held that because the withdrawal occurred before the evidence was discovered, the continued search was unlawful. Taken together, these cases establish that the scope of consent is governed by objective reasonableness. Officers must remain within the specific purpose of the consent given, and individuals retain the right to withdraw that consent at any point before the search is complete. What happens if someone other than the suspect or owner may legally authorize police to conduct a search? This question arises when a third party has shared use, access, or control over the property being seized or searched. In Frazier v. Cupp, the Supreme Court held that when a person allows another to share use of their property, they assume the risk that the co-user may consent to a search. Because Frazier allowed his cousin to jointly use a duffel bag, the cousin had authority to permit the police to search it. The Supreme Court clarified the broader rules governing third-party consent in Illinois v. Rodriguez. The court held that police may rely on consent given by someone who has common authority, meaning joint access or control for most purposes. Importantly, police may also rely on apparent authority, meaning the search is valid if officers reasonably but mistakenly believe the consenting person had authority. Common authority depends on shared use, not ownership. For example, roommates may consent to searches of shared living spaces, but not to each other's private bedrooms. Similarly, one spouse may consent to searches of shared areas of a home, but not areas under the exclusive control of the other spouse. Some relationships categorically lack authority. Landlords cannot consent to searches of tenants' apartments, motel clerks cannot consent to searches of rented rooms, and children cannot consent to searches of their parents' homes, although parents can consent to searches of the juvenile's room. The doctrine of apparent authority remains controversial. While the Supreme Court permits police to rely on reasonable mistakes, some state courts have rejected this rule, concluding that privacy rights should not depend on police error, even when the error is reasonable. The chart in your book is incredibly useful, and I would encourage you to review it in advance of the midterm. One piece of it that I find really interesting is the employer-employee relationship. An employer may give consent to a search of all areas other than those with a high expectation of privacy, such as a locked desk drawer in an office. However, sometimes shared locker space has been deemed to be allowed searched under employer consent. Further, an individual who parks a car in a garage and leaves the key with the attendant assumes the risk that consent will be given to search the car. In Illinois v. Rodriguez, the Supreme Court addressed whether police may rely on apparent third-party authority when conducting a warrantless search. Police were called to a home in Chicago, where they encountered Gail Fisher, who appeared badly beaten and claimed she had been assaulted earlier that day by Edward Rodriguez in an apartment they had once shared. Fisher told officers that Rodriguez was currently asleep in the apartment and repeatedly referred to it as our apartment. She said she had clothing and furniture there and used a key to unlock the door, allowing officers to enter. Once inside, officers observed drug paraphernalia and cocaine in plain view, proceeded to the bedroom, arrested Rodriguez, and seized additional drugs. No search warrant or arrest warrant had been obtained. Rodriguez moved to suppress the evidence, arguing that Fisher did not actually have authority to consent. Courts below agreed, finding that Fisher had moved out weeks earlier, no longer lived there, did not pay rent, did not have free access, and lacked joint control of the apartment. The Supreme Court agreed that Fisher lacked actual authority, but nevertheless upheld the search under the doctrine of apparent authority. The court held that a warrantless entry is valid when officers reasonably believe that the consenting party has common authority, even if that belief later proves mistaken. The court emphasized that the Fourth Amendment requires reasonableness, not perfection, and that officers must be allowed some leeway to make reasonable judgments in fast-moving and ambiguous situations. The key question is whether the facts available at the time would cause a reasonable officer to believe that consent was valid. However, the court cautioned that police may not blindly accept claims of authority and must investigate further when circumstances create doubt. The Supreme Court has addressed consent searches involving co-occupants in several cases. In United States v. Matlock, William Earl Matlock lived in a house with Gail Graff, her son, her mother, and other family members. When police arrested Matlock in the front yard, Graff consented to search of the bedroom she jointly occupied with Matlock. The officers found cash in a diaper bag. The court held that Graff had common authority over the bedroom, and Matlock had assumed the risk that she might consent to a search of the areas that they shared. However, a question arises. What if Matlock had refused consent while Graff consented? This situation was addressed decades later in Georgia v. Randolph. Police responded to a domestic dispute at the Randolph home. Janet Randolph consented to a search, but her husband, Scott, unequivocally refused. The Supreme Court held that a physically present resident's refusal trumps another resident's consent. Warrantless entry and search in these circumstances are not reasonable, and the court emphasized that police may not remove a potentially objecting tenant simply to avoid the conflict. In contrast, in Fernandez v. California, the court clarified the limits of Randolph. Police arrived in an apartment where Roxanne Rojas had been assaulted. Walter Fernandez, her husband, was present, refused consent, and was lawfully arrested and removed. About an hour later, Rojas consented to a search, and officers discovered evidence linking Fernandez to a robbery. The Supreme Court held the Randolph applies only when the objecting occupant is physically present. Once the objector is absent due to lawful detention or arrest, consent from the remaining occupant is valid. Fernandez demonstrates a practical distinction. The court balances residents' privacy rights against police authority, acknowledging that an absent objector cannot block consent from someone who remains in control of the premises. When we read Fernandez next, consider whether this approach aligns with or diverges from Randolph. In Fernandez v. California, 571 U.S. 292, Justice Alito and the rest of the Supreme Court considered whether police can rely on the consent of one co-occupant to search a home when another resident has previously objected but is absent due to a lawful arrest. The case arose after police responded to a domestic disturbance. Walter Fernandez had assaulted Roxanne Rojas, and a bystander, Abel Lopez, was suspected of gang involvement. When officers arrived at the apartment, Rojas answered the door holding her baby, visibly injured, while Fernandez, wearing only boxer shorts, refused consent and asserted his rights. The police lawfully arrested Fernandez outside the apartment. Approximately 1 hour later, with Fernandez absent, Rojas gave oral and written consent to search the premises. The search uncovered gang paraphernalia, a butterfly knife, clothing worn during a robbery, ammunition, and a sawed-off shotgun that Rojas' young son had access to. The Supreme Court held that Randolph is limited to situations in which the objecting resident is physically present. Because Fernandez was absent due to his lawful arrest, Rojas' consent was valid and sufficient to justify the search. And the court explained that extending Randolph to absent occupants would create impractical rules, such as objections lasting indefinitely, questions about continuing authority, and confusion for law enforcement about which consent is valid. The court emphasized that a consenting occupant retains the right to invite police into the home, and that consent remains valid when the objector is lawfully present. The court also noted that consent searches are a recognized exception to the warrant requirement, and that requiring a warrant in situations like this would unduly burden law enforcement and willing occupants. The objective reasonableness standards apply, and Police officers may rely on the consent of an absent, lawfully detained occupant. The dissent, led by Justice Ginsburg, argued that Fernandez's objection should remain valid despite his removal and that obtaining a warrant would have fully protected the Fourth Amendment rights. In addition to searches incident to arrest and consent searches, the Fourth Amendment allows a third type of warrantless search for automobiles, the automobile exception. This exception permits police to search a vehicle without a warrant when they have probable cause to believe it contains contraband or evidence of a crime. The Supreme Court first recognized this principle in Carroll v. United States in 1925. In that case, George Carroll and John Kiro were convicted of transporting alcohol during Prohibition. They challenged the warrantless search of their car, but the court held that the mobility of automobiles made it impracticable to require a warrant because the vehicle could quickly move out of reach of law enforcement. Later cases reinforced this reasoning. In Chambers v. Maroney, the court emphasized that the car's mobility, the alertness of its occupants, and the risk that evidence might be lost justified an immediate search. Even if the vehicle is later impounded, the automobile exception can still apply. In Texas v. White, the court confirmed that officers with probable cause may search a vehicle even after it has been immobilized at the police station because the justification for the search, the probable cause itself, remains. The automobile exception is not based solely on mobility. In California v. Carney, the Supreme Court clarified that warrantless vehicle searches are also justified by a reduced expectation of privacy. In Carney, federal agents searched a motorhome parked in a public lot and discovered marijuana and drug paraphernalia. The court explained that vehicles, including motorhomes, have a lower expectation of privacy because they travel on public roads, are subject to licensing and inspection requirements, and their interiors are often observable. The court rejected the argument that a motorhome should receive the same privacy protections as a house, holding that a warrant might only be required if the vehicle is situated in a way that objectively indicates it's being used as a residence. Thus, the two main justifications for warrantless automobile searches are mobility, which is the ability of a vehicle to move quickly, and reduced privacy expectations due to regulation and public use. These principles allow police to act promptly when they have probable cause, balancing law enforcement needs with Fourth Amendment protections. When reading Carney, it's worth considering whether a motorhome truly warrants less privacy than a home, and whether a search should require a warrant once the vehicle is in police custody. In California v. Carney, 471 U.S. 386, 1985, the Supreme Court granted cert to determine whether federal agents violated the Fourth Amendment when they conducted a warrantless search based on probable cause of a fully mobile motorhome located in a public lot. On May 31, 1979, DEA agent Robert Williams observed Charles Carney approach a youth in downtown San Diego, and the two entered a Dodge Mini motorhome parked nearby. Just so you know, a Dodge Mini motorhome is very much like a van. It's just a little bit bigger. So I don't want you guys thinking of like a fifth wheel or like an RV or something like that. This is very small, very much van-like. Once inside, they closed the window shades. Agent Williams had received uncorroborated reports that the motorhome had previously been used for exchanging marijuana for sex. The agents maintained surveillance for over an hour. When the youth exited the motorhome, he was stopped and disclosed that he had received marijuana from Carney in exchange for allowing sexual contact. At the agent's request, the youth returned to the motorhome and knocked on the door, prompting Carney to step out. Without a warrant or consent, one agent entered the vehicle and observed marijuana, plastic bags, and a scale. Carney was arrested and the motorhome was seized. A subsequent search at the police station revealed additional marijuana. Carney was charged with possession of marijuana for sale. The preliminary hearing in Superior Court denied his motion to suppress the evidence, but the California Supreme Court reversed, reasoning that motorhomes, by their primary function, are more dwelling than vehicle. The Supreme Court reaffirmed that the Fourth Amendment generally requires a warrant for searches of homes, but acknowledged long-standing exceptions, including the automobile exception first articulated in Carroll v. United States. The court explained that vehicles, unlike stationary structures, are readily mobile, and this mobility creates circumstances in which a warrant may be impracticable. Cases such as Chambers v. Maroney and United States v. Ross emphasize that immediate searches are sometimes necessary because a vehicle in transit may move beyond police reach. However, mobility alone is not the only justification for this exception. The court explained that individuals have a reduced expectation of privacy in motor vehicles because vehicles are subject to pervasive public regulation, including licensing, inspection, and traffic rules. The court cited prior cases demonstrating that the passenger compartment, closed containers, and even locked trunks fall under this reduced expectation of privacy. Applying these principles to Carney, the court held that his motor home was readily mobile, situated in a public place, and objectively being used as a vehicle rather than a residence. While the motor home could function as living quarters, its location, mobility, and regulatory status brought it within the automobile exception. Thus, the warrantless search was reasonable under the Fourth Amendment. The court emphasized that distinguishing worthy from unworthy vehicles based on size, amenities, or residential use would undermine the purpose of the automobile exception. The court concluded that the exception should apply whenever a vehicle is readily mobile and not objectively being used as a residence, balancing law enforcement needs with privacy interests. Justice Stevens, joined by Justices Brennan and Marshall, dissented, arguing that motor homes often function as temporary living spaces and should receive privacy protections comparable to those of homes. He contended that warrantless searches of such vehicles are presumptively unreasonable absent exigent circumstances. Briefly, based on the case of Collins v. Virginia, Officer Rhodes had probable cause to believe that Ryan Collins' motorcycle was stolen, but the motorcycle was parked within the curtilage of Collins' home. When Rhodes lifted a tarp covering the motorcycle, he discovered it was stolen. The Supreme Court held that the automobile exception did not allow the officers to enter a home's curtilage without a warrant, so the search was deemed unconstitutional, proving that a home receives much higher privacy interests than a vehicle. The Supreme Court has held that individuals generally retain a reasonable expectation of privacy in enclosed containers, which include luggage, backpacks, boxes, and paper bags. In United States v. Chadwick, federal agents had probable cause to believe a footlocker contained narcotics, but the court held that a warrant was required to open it because luggage is intended to hold personal effects and is not subject to regular public scrutiny. In contrast, containers that communicate their contents by their appearance may be opened without a warrant. The court has struggled with whether a container inside an automobile loses its privacy protection. The settled rule is that a container in a car may be searched without a warrant when there is probable cause to believe it contains contraband. Two scenarios illustrate the rule. Probable cause limited to the container. Police may search a container inside a car if they have probable cause to believe the container itself holds contraband. For example, a drug courier places a backpack in a car. The police may seize and search the backpack without a warrant. Probable cause extends to the vehicle. Police may search the entire vehicle and any containers that could hold the contraband if they have probable cause to believe illegal items are somewhere in the car. In California v. Acevedo, the police had probable cause to believe a paper bag Acevedo placed in his trunk contained marijuana. The court held that the officers could lawfully search the bag without a warrant. However, the police could not search other parts of the car without separate probable cause. The court has raised the question of whether it makes sense to treat containers differently based on whether they are inside or outside of a vehicle. In Wyoming v. Houghton, a police officer stopped David Young for speeding and suspected narcotics were in the car. The officer opened a passenger, Sandra Houghton's purse. The key question was whether probable cause to search the vehicle extended to containers belonging to passengers or if it was limited to containers belonging to the driver. In Wyoming v. Houghton, 526 U.S. 295, 1999, the Supreme Court asked whether police may search a passenger's personal belongings in a car when they have probable cause to believe the vehicle contains contraband. On July 23, 1995, a Wyoming Highway Patrol officer stopped a car for speeding and a faulty brake light. The driver, David Young, had a hypodermic syringe in his pocket, which he admitted using for drugs. The officer searched the car for contraband and found a purse belonging to passenger Sandra Houghton. Inside the purse were syringes and methamphetamine. Houghton was charged with felony possession. The Wyoming Supreme Court initially reversed her conviction, holding that the officer lacked probable cause to search her personal property. The Supreme Court noted that police had probable cause to believe contraband was in the vehicle. Historical precedent, including Carroll v. United States and United States v. Ross, supported the idea that if probable cause exists to search a car, police may search every part of the vehicle, including containers where contraband might be hidden, without distinguishing between driver or passenger property. Passengers have a reduced expectation of privacy in their belongings when traveling in a car, and law enforcement interests are substantial, especially given the ready mobility of vehicles and the risk of evidence being moved or destroyed. The court rejected a rule requiring individualized probable cause for passengers' property, noting practical difficulties and the potential for abuse if exceptions were widely known. Police with probable cause to search a car may search passengers' belongings capable of concealing contraband, regardless of ownership or presence of the passenger. Justices Stevens, Souter, and Ginsburg dissented. They argued that passengers' privacy interests should not be ignored and probable cause should be required to search a passenger's belongings. The majority's rule unfairly extends the automobile exception based on the driver's conduct, diminishing privacy protections, which are unnecessary. Other types of warrantless searches include the plain view exception, where an officer who is legally present may seize evidence without a warrant if there is probable cause to believe it is connected to criminal activity. Another example of a warrantless search is frisks. Police may frisk an individual stopped on reasonable suspicion if the officer reasonably fears the person is armed and dangerous. This is Terry v. Ohio. And exigent circumstances. Police may enter a dwelling without a warrant to prevent evidence destruction, pursue a fleeing suspect, or respond to an immediate threat. However, the search must be limited to its purpose, and anything beyond requires a warrant. The court also allows warrantless seizure of evidence at risk of imminent destruction, such as scraping fingernails for homicide evidence. Automobiles and personal belongings may be inventoried when an individual is arrested or a vehicle is impounded. An inventory records possessions such as jewelry, cash, keys, credit cards, and identification. Inventory searches are administrative, not investigatory, and serve four main purposes. They prevent false claims of theft by the police, protect the property from loss or damage, ensure the safety of the arrestee, officers, and those around them from potentially dangerous items, and they confirm the identity of the arrestee. Inventory searches are considered reasonable under the Fourth Amendment because the individual is already in custody and the intrusion on their privacy is minimal. Key principles to inventories include uniformity. Inventories must follow standardized procedures treating all objects and persons alike. No probable cause is required, and officers do not need that to conduct an inventory of objects or containers. Reasonable procedures. Courts uphold inventories if they are designed to protect property, ensure safety, and prevent false claims. And no criminal investigation. Inventories conducted to investigate a crime are inherently invalid. There are certain key cases that the Supreme Court has decided with respect to inventories. In Illinois v. Lafayette, amphetamines were found in a shoulder bag during a station house inventory, and they were deemed lawfully seized. In South Dakota v. Opperman, warrantless inventories of an impounded car's contents were also upheld. In Colorado v. Bertine, a lawful inventory of an arrested driver's backpack containing narcotics was upheld by the Supreme Court. But there are instances where the court has not upheld an inventory. In Florida v. Wells, an inventory was deemed invalid because there was no standardized policy by the police department, and officers left decisions to their individual discretion. Inventory searches are considered special needs searches because they serve administrative purposes rather than investigating criminal activity. In conclusion, the Fourth Amendment establishes a strong preference for searches based on warrants supported by probable cause. This ensures that a neutral magistrate, rather than a police officer acting in the moment, determines whether a search is justified. Warrants must particularly describe the items to be seized and the locations to be searched, and generally require police to knock and announce their presence. Except when immediate entry is necessary to protect safety, prevent evidence destruction, or avoid futility. Despite this preference, the Supreme Court recognizes several warrantless searches as reasonable. These include searches incident to arrest, which allow police to search an arrestee in areas under their immediate control to protect officers and preserve evidence. Under Arizona v. Gantt, this includes the passenger compartment and containers in an automobile if the arrestee is within reaching distance or if evidence of the offense is reasonably believed to be inside. Consent searches, which are valid when voluntary and not coerced, with the scope determined by what a reasonable person would understand. Consent can be limited or withdrawn, and third-party consent is valid only when the consenting party has authority. The automobile exception, permitting warrantless searches of vehicles and containers within them when there is probable cause that contraband or evidence is present. And other recognized warrantless searches include plain view seizures, frisks based on reasonable suspicion, and exigent circumstances. Finally, inventory searches of arrestees or impounded vehicles are considered special needs searches. These administrative inventories aim to protect property, prevent false claims, and ensure safety rather than to investigate criminal activity. Inventories must follow standardized procedures, but no probable cause is required. Overall, the Fourth Amendment balances individual privacy with effective law enforcement. Warrants remain the gold standard, but carefully defined exceptions ensure that police can act reasonably and promptly when circumstances demand. I'll see you in Chapter 7.